Thank you, Bonnie.
Okay, I thank you all for bearing with us. You that aren't members, we welcome you, but just to give you an introduction to our organization, that's how we operate. All of our board members there are no paid positions. Everybody volunteers their time. And John is he's our best example here. He's spent a lot more time since we've been locked down and doing meeting virtually. Not that he didn't spend a lot of time in the past when we met. He does a great job of lining up our programs, getting speakers to come, doing a little arm twisting to get some of them that are maybe a little unwilling to meet with us and take those tough questions. But we appreciate everybody's effort to bring it all together. So with that business out of the way, John, I'll let you turn over for introduction of Julie.
So happy to have Julie. Last time you were here was, I believe, one of our Saturday courses, although you've been so gracious to come to our regular main events like this in person so many times. This is the first time we've been fortunate enough to have you virtually. We really appreciate your coming and visiting with us. We always learn so much, and it's just I know your time is so valuable, so we so much appreciate it. So it's all yours, Julie. I don't even know what to say other than just please help us, and thank you so much.
Well, thank you everybody for having me. Like I said, this is one of my favorite groups to speak with because I always get some of the best questions and honestly, sometimes the most thought-provoking circumstances. So I'm Julie Ostrom. I've been an attorney in St. Louis since 2009. My area of practice specifically is in landlord-tenant law. However, I also practice in business, corporate, but specifically helping people who invest in real estate. So I'm going to share my screen here for everyone, and hopefully, does everyone see that? Is that working yet?
That's the office.
All right, yeah. So we have awnings now. That's very exciting, right? We've made some improvements to our building. So I am an attorney at BECK Ostrom Suite. We're a boutique real estate firm. So we do everything from land tax, landlord-tenant, buy-sell, representation for flippers, and then even real estate litigation, so boundary disputes and things along that line. So pretty much anything related to the real estate industry, we do. We also represent individuals that want to set up small businesses, specifically real estate holding companies for purposes of owning and holding real estate that they want to rent. So this is sort of a mixed bag because COVID has created a lot of problems. I mean, it's created a lot of questions. So one of the things that I know I always talk to you guys about is business structure, right? So is there a reason to have any sort of business structure, right? Do I need an LLC? Do I need a corporation? And there's a variety of different options depending upon what your business actually is. So generally, as a real estate holding company, a corporation doesn't make a lot of sense. It has a different tax structure. Usually you give more to the federal government than you actually intend, which is why for a holding company, or even an entity that you intend to hold real estate in while you're rehabbing it in order to sell it, you're better off with an LLC. There's no ongoing corporate requirements. There aren't regular yearly fees like there are with a corporation. And here in Missouri, we have the benefit of what's called a series LLC. So this is a recommendation I make to all clients who intend to hold property for rent. So when we talk about a series LLC, it's a linear thing. It's not like a parent with a bunch of subsidiaries, but what it allows you to do is separate out individual properties into their own entity while still maintaining only one security deposit account, one bank account. So it eliminates some of the onerous tasks that comes with having a lot of LLCs, but at the same time, it also allows you to separate your liability property by property. Some people choose to own their property in a trust, and I would still recommend, because a trust can be pierced for personal purposes. If you were to be sued, one of the goals is to avoid any sort of liability that could pierce through to your individual and family assets. However, I would suggest having your LLC owned by a trust, because part of estate planning and part of your long-term planning as a real estate investor, it makes sense to have a trust in place. And I do have clients ask me, well, why shouldn't I just own my property in my personal name? And a reason not to do that is because it leads to personal liability to you individually, meaning if somebody were to sue you based on something that happened on a property that you own, whether it's a contractor or renter, and they are able to pierce through to your individual assets, it means every individual asset would be subject to collection. So when I say this, people ask me, well, why isn't insurance enough? I have an umbrella policy. As a property owner, a landlord in particular, you need to be really aware of what your policy limits are and what your exclusions are. So a typical landlord policy in Missouri excludes lead, it excludes mold, so and it excludes discrimination. So those three things are what are considered wanton and willful behavior. So your policy right now covers negligence. You forget to shovel the snow, you have a tenant that slips and falls. Yes, your insurance is going to step in and defend you and protect you and pay any sort of claims that might be had. But if you get sued for a different reason, your insurance may not be there to protect you. And it's important to really familiarize yourself with that policy. You can sometimes pay extra to add different riders onto it, but I do have one little story to share. I have a client who I've worked with him for many years, and he is a really sophisticated real estate investor, but he never wanted, he had an LLC that he put on his leases. He had an LLC that he used to collect rents, but he never wanted to actually deed his properties into his LLC because he wanted to conduct his own evictions. In Missouri, if you are a corporation or an LLC, you have to be represented by an attorney. So it had always been his plan to be a pro se landlord on the Friday dockets when he needed to evict tenants. He had a discrimination complaint filed against him, assumed immediately he could call his insurance company. He made the claim and they denied it. So he had to pursue mediation and go through the litigation process, and the claim was bogus. I mean, he didn't lose, but he spent $20,000 in attorney's fees. So being aware that insurance isn't enough, had that individual property been in an LLC, I could have told the attorney who represented the tenant to go pound sand, essentially, because what are you going to do? You're going to take a property that's leveraged, right? They're not going to collect anything from that. And it would have brought his fees and costs for litigation way down. But he didn't, so this is one of the reasons why I love talking to people like all of you. I want you to know what the options are out there, so that way you can make educated business decisions for yourself. If you own one rental property, your liability is very low, but if you build a portfolio, that liability increases. Another really important part here is having a lease agreement, and I do have a whole slide on leases. And I am going to try to go through stuff relatively quickly because I think that right now is the time that's more important to me for questions. I don't mind being interrupted, although I'm not the moderator on this, so I'm not sure if I will see hands being raised. So if someone feels like they want to jump in and interrupt me, by all means, it doesn't bother me at all. So I think we went through enough of me and harping on my insurance policy. So the liability here that comes along, the protections you get with an LLC is, yes, slip and fall, but you also get benefits from mold, lead-based paint. If you don't have a lead-based paint disclosure attached to your lease, add one immediately. Premises liability, which is essentially any sort of liability that can come upon a property owner as a result of what's considered a dangerous condition on the property. And this can happen even while you're flipping a property. If you have different sets of subcontractors coming onto the property, if they get injured and their employer doesn't have workers' comp insurance, which has happened. Many small subcontractors have fraudulent workers' comp policies. Even if you think you're doing the best you can do by getting COIs and making sure you have lien waivers, you can still end up getting hit with a lawsuit based on some sort of premise liability that maybe you're not even sure exists. And then there's also personal lawsuits. And if somebody were to sue you separately or you were to be divorced, having all of your stuff separated into an LLC then separates your investment from your personal assets, which is a benefit as well. Another good thing about an LLC is if you don't want to manage your properties, you can identify a manager. You can have a manager managed entity that you can change. It doesn't change the ownership of the property, doesn't change the ownership of the entity, but it allows you to have different people make decisions on behalf of your company without you having to necessarily step in and always be the one in control. So another discussion topic that comes up is, how do I have my LLC taxed? An LLC that's a single member is considered a disregarded entity, which means it's taxed as a pass-through entity. And an LLC that has more than one member by default is taxed as a partnership. This is the absolute best taxation structure for a property owner that simply wants to hold real estate for purposes of renting or while they're rehabbing it and then eventually selling it. S Corp elections, C Corp elections, these will just create extra or double taxation for you. Some accountants will suggest S Corp elections, but really, if you're going to set up a separate LLC as a management company for you to do your own management, then you need a separate LLC that then would be taxed as an S Corp. But it's a benefit that you get to choose. An LLC is like a chameleon. You can pick whatever tax structure you want, as opposed to setting up an S corporation or a C corporation. Part
Hey,
of,
Julie,
yes.
on those S corps, I've always been told they flow right through just like an LLC does. It just gives you the advantage of an S corp to buy you stuff.
Well, they do flow through similar to a partnership, as in you get a K1, just like you would if you had a partnership structure. But an S Corp election has different set of deductions to it. And so if you S Corp elected, you could then, if you were managing your own properties, it would probably be, it could be a benefit. And again, this is an accountant question, but I will say the rental income is passive income. It's taxed at a lower rate than, say, active income, which is W-2 income or 1099 income, right? Income you're actually personally generating versus owning real estate and then having rents come in. So that there is a benefit depending upon, and was that Dwayne?
Yes.
Yes. Okay. So I know you're enough about your business though to know that you probably do get a benefit from an S Corp election.
Well,
But
I don't have one.
you're much more active. There is a lot of property owners that just don't want anything to do with managing their property. They want to hire a management company, pay the fee, and just let the income roll in. Does that make sense?
I like the last statement.
I think that's what we all are hoping for. COVID is really messing with everybody. So also part of having an LLC means you have to have an operating agreement. That operating agreement defines all of the sort of, not the day-to-day management of an LLC, but the legal management of an LLC. So you can define, how do you get cash distributions? Do you take them all as a distribution, which is then subsequently taxed at the end of the year? Do you want to pay yourself as an employee? And that provides you the benefit of a payroll tax deduction. So you get a lot of control there. You also, if you take money from private investors who they just want to give the money and get their money back over time, you can control ownership levels and voting rights. So you can have silent investors, and that still allows you to continue moving forward with your business while taking private money from individuals that are interested in real estate investment. You also get to define exactly when an entity is dissolved. So, you know, if you go into business with a partner and each of you put in a certain amount of cash, and the goal is we're going to buy 5 properties and flip them. And once we're done with those 5 properties, that triggers dissolution. It ends the relationship. You have the ability to create a lot of boundaries here and define what the arrangement is between parties. And you can also choose to transfer on death without the effect of probate. You can identify that in your operating agreement. And if something were to happen to you, it immediately in a non-probate transfers the ownership to a child or a spouse or someone who can step in and take over management of your properties.
And that's in an LLC or an S Corp?
An LLC. So S Corp, C Corp, partnership, that's all IRS language.
Sure.
So like I
Gotcha.
said, an LLC, it's a chameleon entity. It can be taxed however you choose, and you can change it from year to year. So
Yes.
if you have a suggestion, oh, I should be taxed as an S Corp, you can try it for a year. And if it doesn't work out or the structure isn't the best savings for you, you can change it back.
Yes. When you're done, I want to talk about trust probably at the end of this because it will bore most people, but I have some hard questions.
Okay.
Sorry,
Um,
sorry.
So next thing about an LLC is it really separates you from your own personal assets. And part of that is you get what's called an EIN number, an employer identification number, which is used, it's basically the social security number for your entity. You set up bank accounts with that number as opposed to in your personal name or with your own social security number. All of this is evidence that when we do have a lawsuit, we use to show that our client properly set up a corporate entity in order to protect themselves and limit their liability. It's separate bank accounts, separate everything. And now that doesn't mean you collect your rents, it goes into your LLC account, and then you can cut a check to yourself. But you need to always flow money through that entity, because if you don't, if you let tenants pay you individually, or if you pay contractors out of your own individual account, then that's what we call that piercing. It's part of the piercing corporate veil philosophy, or I mean, because that's really your commingling funds. Keep your funds separate, but it doesn't mean that you don't get to take money out of that entity. But it means you pay your insurance bill for your properties out of that entity. You pay your contractors out of that entity. All of that is evidence that you are separating your individual self from your company.
Well, okay, question on that separate bank accounts. Because we have a past, I'm not aware of also that the old way was we'd have one account, but they have to be tracked absolutely separately. And then to move one money to different accounts, it's got to pay to us and then put back in, correct?
Correct.
So you can get by with one account.
Well, so if you have a series entity, the benefit of the series is that you have one account for the series name. But I will say right now, I mean, you have to have more than one account because you have to have a security deposit account. So all your security deposits need to be segregated. About 2 months or 2 years ago, the Supreme Court of Missouri issued an order that said for all landlords, if every tenant vacated at the same time and all were due their full security deposit back, you need to have an account with that much money in it.
Yeah.
And filling it in later or filling it in when you think there might be a problem isn't good enough. So, but yes, what you're saying is that if you, like I said, if you have a series entity, you have an account in the name of that series. And then every property is owned in its own individual series, which means if there's a slip and fall on series 2, they can only sue series 2. But your accounting is easy because you only have to have one operating account and one security deposit account.
I don't do
That actually
series.
leads perfectly into what we were talking about. Is that your series is essentially, like I said, it's think about it like it's linear. You have your LLC, Julie LLC, and then underneath Julie LLC, I have Julie LLC Series 1, Julie LLC Series 2, on infinitum. There's no maximum amount of series you can have under one entity. And each property I own, 3,500 Magnolia is owned by Julie Series 1, right? So the benefit there is I can't sue anything other than that series entity if there's any sort of issue. And if I'm filing an eviction on your behalf, I sue on behalf of that series entity. But you only have to have those bank accounts for this, for your big, essentially the Julie LLC, which is, like I said, from an accounting standpoint, it makes it a lot easier than the people who have each property in a separate LLC requires a separate EIN number and a separate bank account for each entity in order to keep from commingling funds. So it's really why if you're going to hold property for rental, series is absolutely the easiest. Now, the statute requires that each landlord separately account for each unit. You're going to do that anyways. You're going to keep a separate rent ledger for each tenant. You're going to keep a separate ledger for any sort of work or maintenance you do on the property for purposes of depreciation. You're going to do that for your tax return. So the statute is definitely leaving it open enough for this to make it easier on landlords that are holding rental property over a long period of time.
Sorry, I had a quick question. Does the application for a series LLC differ in any significant way from a regular LLC? How does that work even?
It differs, yes, significantly. I mean, you have to attach a series form to your articles of organization that identify the name of each individual series. So
Oh,
the
basically-
application becomes larger, yes.
Okay, so every time you add a property to your portfolio, you have to append an additional document, that sort of thing?
So
Mhm.
maybe, so generally what I suggest is if someone comes to me and says, I have 5 rental properties, I'm never buying any more, then yeah, I would just set up the 5. But if I know that you're going to build a portfolio, I build extra series in on the initial filing. And then, yes, if you get to where you have a portfolio of 20 rental properties and it's time to add more, we just amend the LLC and add additional series. But I think if your goal is to build a portfolio, then you should give yourself room to do that. Because it's not
Sure.
any more expensive, right? The filing fee, the price of it isn't anymore. So it's worth it. If you think you're going to build a portfolio, just set up 20 to begin with. That way you're ready to go.
Sure, sure.
So one question that comes up often about having LLCs though is financing, right? That banks don't want to lend to LLCs, or you have to get a corporate loan, which has a higher interest rate. That is something that's been coming up, especially now. So you can personally guarantee those loans, which the banks are going to ask for anyways. Or I have clients that take the loans initially in their individual name, put the property in their individual name, and then subsequently transfer it into their LLC. The fear there is, what about the due on sale clause? There's a clause in the deed of trust and in the promissory note that says if you transfer this property without the bank's permission, they have a right to foreclose. Practical experience with this is there's not very many banks that check. If they get their check every month, they don't look at all, right? But Bank of America, I have found, will do a periodic yearly check on making sure that things are titled the way that they want them to. So when you initially are purchasing, letting the bank know that you're interested in buying with an LLC for purposes of estate planning and liability protection is honestly the best policy. And I haven't had any bank that has had an issue with it. And the very, very few times in the last 11 years I've ever had a bank say, well, wait, your loan is in your individual name, but your property is now in an LLC. We just deeded it back. They didn't foreclose. So that fear that's there, they're not going to spend the money or the time to try to foreclose on your property. But like I said, probably 5 times in 11 years, I have seen a bank actually bring that up. So I know it's a concern for some investors. I haven't, again, it's just not, practically speaking, it just isn't an issue that seems to be a problem. But again, when you're purchasing, if you're going to get a loan or any sort of financing, it's important to let them know that you want to put it into an LLC at closing.
Julie, if you issue, like you said, you personally guarantee it, or the loans in your name, does that negate any of the asset protection that you have with the LLC? So if you have your LLC, if you have your loan that's either provided to you or that you've personally guaranteed, and your house that's actually deeded to your LLC, does the mixing of your personal loan and the LLC negate any of the asset protection that you'd have?
No, not from other creditors. So if your bank has a personal guarantee against you, or if you've signed a personal guarantee for anything, that the bank is always going to have the ability to come after other assets.
Yeah, and I was thinking, I guess, more in terms of a liability piece of it. So if you get sued, are you more open now to
No,
personally
I mean, as long as your property is deeded into the name of your entity, then that's the liability protection from third parties. But again, your deed, even with your bank, your deed of trust limits they can come after you for purposes of foreclosing on the real estate if you default. And then if there is a deficiency, they would have a right to come after you personally. But that, because you have that relationship with the bank, does not mean that third parties then have a right to pierce.
Okay, no, thank you.
Julie, Diana has a question here. She can't unmute, and I wonder if I could just ask it real quick on the security deposits.
Yeah, I do have a slide on security deposits actually, but yeah, I'm happy. Yeah.
Okay, would you like to do the slide first, or you want me to go ahead and just ask it real quick?
No, go ahead and ask it.
Okay, she says, does keeping security deposits in a savings account and your day-to-day business monies in the checking account, all in the same bank account, does that meet the statute?
All in the same bank or all in the same bank
I
account?
think the same bank is what it actually means, but I'm not, yeah, but that's. the-
Yes. So the one point I will make though is a savings account generally is an interest bearing account. In the state of Missouri, if you want to put your security deposits in an interest bearing account, your lease agreement needs to include a clause that says the landlord has a right to put the security deposits in an interest bearing account and that they have a right to keep it and the tenant does not have any claim for it. Otherwise, you have to account for the interest that was earned on that individual security deposit and give it to the tenant when they vacate.
Okay,
No one wants to do that. I mean, that's an accounting nightmare, period. But that is an easy clause to add to any lease agreement. So you absolutely can keep them in an interest-bearing account. But if it's in the same bank, there's no issues there. You just want it in a separate account.
okay. She said same bank account, so I'm assuming it's one of those that is a part, I guess it's both ways. I'm not sure. I don't have one like that, but I think it says account.
So then to be clear, it should be in a separate account
Separate
with a
account.
separate account number. It doesn't, yeah, there, and I mean, title it security deposit account, right? And just dump that money in there. But definitely commingling rents and security deposits
Mhm.
is a no-no under Missouri law.
Thank you. Thank you.
So this is good segue though, because the lease agreement is so important. I have clients that just don't like written leases. They love a verbal lease. And it doesn't mean you can't have a month-to-month tenancy with a written lease. You can absolutely identify that tenancy as month-to-month. It doesn't have to be from year to year. But a written lease is so important because it is incredibly protective of a landlord. So it identifies essentially the relationship between the landlord and tenant. Whose responsibility is what? And it comes down to everything from ice and snow removal to the date that rent is due. You know, you can identify that this particular tenant needs to pay their rent on the 10th of the month because that's their pay periods. But even more, there's so many protections that you can build into your lease. A requirement that your tenant have renter's insurance is really important because it's a defense for landlords. And I will say, I was a property manager for many years because I went to law school at night. So I worked as a property manager during the day. I've been in most of your shoes on many occasions. So a tenant will say, yeah, here's my renter insurance policy, and they'll never pay the premium again. But you did your due diligence. And so when power goes out and they lose everything in their refrigerator, and now all of a sudden they want the landlord to give them $500 to replace their last Sam's Club order, you can say, well, wait, that's on your renter's insurance policy. And we talked about that when you signed your lease. You said you had a policy, you need to reach out to them. So there is those parameters, again, inside the lease agreement can be incredibly protective. Attorney's fees are another great example. Attorney's fees in Missouri are under what's called the American rule, which means each party bears their own costs and fees unless there's a written agreement that identifies who pays attorney's fees or the statute allows for attorney's fees. So here in Missouri, when you're evicting a tenant, or if there's a breach of contract issue with a contractor, those statutes do not automatically allow for attorney's fees. So having a written agreement in place that says the prevailing party or the landlord has a right to collect those fees if they have to pursue court action to enforce their agreement is really important, because otherwise you're going to put those funds out with no hope of getting them back. Another really important thing, really important, is the waiver of jury trial. So there are two types of evictions in Missouri, one of which you can ask for a jury trial. And all that does is ultimately extend the time that the tenant stays in the property without paying rent. So if we have a clause in the lease that waives the right to a jury trial, and I'm really particular about this because I've litigated it enough, I put that clause right above the signature block, and I put an initial block with it. So the tenant, there is no buried on page 16 of the lease on clause 29 where a tenant can make an argument they didn't realize they waived their right to a jury trial. It's clear, it's concise, right above the signature line. And like I said, again, I make it an initial block. So having the jury trial waiver in your lease can absolutely make the eviction process move so much faster, especially because of right now. And I do have some COVID specific eviction related information later on. So I will get to that, but you definitely want to make sure that you have a written lease agreement under all circumstances, because even if you have a tenant that's with you for 15 years and they only sign that lease the very first year they're there, once the lease turns to month, because once the lease hits October 31st, 2020, right? If I continue to reside in your property and I continue to pay rent and you continue to accept it, all the terms of that lease agreement stay in place except for the term. The tenant can't guarantee to stay there until a certain time, and you can't guarantee the tenant will be there until a certain time. Both parties have a right to give 30 days written notice to vacate. But other than that, every other term of that lease is in place and it's enforceable. My parents had a tenant that stayed somewhere for 20 years on the same lease. So yeah, my parents also have owned rental property since I was a small child. So it absolutely is in your favor. And I will always push that no matter what the circumstances are or what your normal practices are, having something in writing is better than nothing. And finally, like I said, you can include a waiver of indemnity. So if there's an injury or a loss, you have a defense in court if a tenant sues you for something to say, well, they signed an agreement that says they would waive their right to pursue this action against me. Okay, so security deposits, we'll go a little more in depth. So security deposits are governed by the statute 535. So it's any deposit of money or property that's given by the tenant to the landlord, basically in order to prevent or give the landlord liquidated damages for damage that occurs to the property beyond what we call reasonable wear and tear. Security deposits have to be segregated. We've talked about this a little bit, but that means they need to be in a separate account. And it's honestly to your benefit to do that anyways. So a security deposit is not yours. It's not the landlord's, it's the tenant's until the tenant vacates. So once the tenant vacates, a landlord has 30 days to conduct an inspection and provide a statement to the tenant. And that statement under the law just has to be mailed. And if you don't have a forwarding address, you mail it to the address of the property that you own that they moved out of. And if it comes back to you, you've met all the requirements necessary. So when it comes to limitations on what you can collect to a security deposit, the Missouri rule is that you can't, at time of movement, you can't collect more than an amount equal to 3 months rent. How you decide to delineate that is up to you. It can be first month's rent, last month's rent, and a security deposit. It can be first month's rent and a double security deposit. I have a lot of clients that, they want tenants that have a 600 credit score or higher, but if their credit score is 550, they'll consider doubling the security deposit, as a way to let somebody in if they don't quite meet all of their criteria. I will say, I really suggest that no one collect last month's rent. And if you do want to delineate as last month's rent, just give them a credit from the very beginning, because last month's rent in litigation causes so many problems. So if you really want to collect the amount equal to 3 first month's rent and a double security deposit, and make sure that security deposit is very clearly delineated, the amount inside your lease agreement. And part of the reason why they have to be kept segregated is because, like I said before, they don't belong to you. They're not yours to use to do maintenance. They're not yours to use for mortgage payments. You're holding them as a fiduciary and trust for the tenant. So I actually do have a fair amount of clients too that don't collect security deposits at all, because they don't want the liability. They don't want the responsibility of what can happen if they fail to return it, if they fail to return it within a certain amount of time. And that 30-day mark is a hard and fast mark. You want an envelope out in the mail with a security deposit settlement statement within 30 days of them vacating the property. If you don't, the statute says that the tenant shall be entitled then, and shall, words matter in the legal system, shall and may, but shall be entitled to double the amount wrongfully withheld. So let's say you do the inspection, you wait 35 days, you're giving them half their security deposit back. You could potentially be on the hook for double of half, right? Which is the whole security deposit. And those timelines are absolutely really important to enforce and keep track of in your own business, because you don't want to end up with a lawsuit that, even though you really didn't do anything wrong, it just took you 35 days to get someone their money back. they now have a cause of action against you for an additional sum. So that gets us to evictions. And I'm like I said, I know a lot of you have been through this before, or you've done your own evictions, but you know, we talk about when it's time to evict someone, and we'll take a step back and suspend COVID for a minute. Generally, you know, your rents are due on the 1st, which means they're late on the 2nd. If you have a grace period, it's still late on the 2nd. Your grace period merely is the period of time in which you can't charge a late fee, right? But letting people go 30, 60 days, I've learned now, and I think a lot of my clients have learned now in particular because of COVID and the shutdowns that happened, is they had tenants that I was filing evictions against in February of this year. Then we shut down a week before their court date. These tenants haven't paid for 8 months. And you guys have bills to pay. You have maintenance to maintain on your properties. You have mortgages. You have taxes due. You have utilities, sewer, water, trash. And without getting rent, it is absolutely turning your business model upside down. So I will always say, you got to be on top of your tenants. And if you get to the 15th of the month and you don't have rent and you don't have communication, it's time to move forward. Whether you file your own evictions or you send them to me or you send them to any other attorney in the St. Louis area, you have to act soon, because it takes 21 days to get to court from the point of filing. If you're at day 15, 21 days later means they already owe you the next month's rent. If we get to court and they contest it, it's 2 more weeks before we have a trial, and then 10 days from that date before you can actually execute and take possession. By that point, you're probably owed 3 months rent. And getting a judgment is great, but getting a judgment from someone that can't pay their rent means you have a piece of paper that says you're owed money. And that's not the same thing as having the cash in hand that you need to pay the banks or your contractors. You know, you're trying to avoid liens if you've had work done. So keeping on top of your tenants, and I was a property manager, so I had a strict rule. By the 5th, if I didn't have rent, I was on the phone. I would go knock on the door, whatever it took to try to get somebody to understand, like, I was going to work with them, but if they didn't communicate with me, I was going to evict them. So we have 2 types of evictions in Missouri, and this is important when we get to our COVID stuff. So one is called a rent in possession. Really simple. Tenant's not paying rent, you can file it. Right? There is no, you can file, if rent's due on the 1st and they haven't paid, you can file it on the 2nd. There's no notice requirement. Getting the notice from the sheriff's department or the process server meets the notice requirement. But the negative of a rent in possession is if you want your tenant out, right? If you actually want somebody to move for whatever reason, you're planning on selling the property, you want to rehab it because you think you can get a higher rent, maybe they're even an inherited tenant. A tenant can pay everything that they owe and the lawsuit is dismissed and they get to stay. The other type of eviction is what we call an unlawful detainer, and that requires a termination of the tenancy. So let's say I'm renting from John, I've lived there for 10 years, and John decides he wants to sell the property. John he serves me with a 30-day notice, and now service, it's best if it's personal, meaning John comes to my door, knocks on the door and says, look, I'm sorry, Julie, but you got 30 days to vacate. If I'm under a traditional lease agreement, I have to give that notice on or before the rent payment due date. So John would need to come on October 30th and give me the notice and say, you have to be out by the end of November. I still owe John my November rent, but I don't actually John doesn't have a right to file his unlawful detainer against me until December 1st, when I have failed to vacate in accordance with his notice. So one of the benefits of an unlawful detainer is there's no counterclaims, there's no affirmative defenses. You own the property, you have a right to possession, they haven't vacated, that's it. There is no fussing and fighting over, did the landlord fix things, like can happen in a rent in possession. Tenants can file counterclaims, they can make things a little more complicated. But the unlawful detainer has extra steps and it takes a little longer to do. But during COVID, what we're finding is the unlawful detainer is actually the better option for landlords that really want to get their tenant out. So then last but not least, the other type of litigation that landlords commonly deal with is security deposit litigation. And I kind of harped on that earlier, but getting sued for failing to return a security deposit is a painful experience because it also requires then, if you sent a statement, for us to go through each individual line item and determine whether or not that damage that you repaired constitutes reasonable wear and tear. And that's always up to the judge, right? So anything related to security deposit litigation, if you can avoid it, timelines, it's really, really important to make sure that you know the tenant moved out on the 16th. I have, 20 days to send that statement. So,
Julie, can I interrupt with a question real quick?
yes.
Please. Earlier you mentioned that collecting the last month's rent in advance was problematic. Can you just touch on that real quickly, please?
So what'll end up happening if you have to terminate your tenant, or if your tenant becomes disgruntled in some way and wants to move out, is they will assume that that means they don't have to pay many months of the last months of rent, right? Or if you're evicting them, it causes issues related to the accounting of what's actually owed to the landlord. So what I would suggest doing is, if you want to take first and last month's rent, then just give them a credit on their ledger right away for the last month's rent. That means they should always be operating with 1 month ahead, right? So that way, when it comes to the accounting, there isn't a question of, well, I paid last month's rent. Well, what was your last month? And what if you breached your lease agreement? What if they moved out before the lease term was over? Well, now you have this last month's rent. Does that apply to the last month they lived there? With judges, it's leeway for them to use their discretion in a way that is in the favor of the tenant. And now, keeping in mind, I feel for my judges, all of the ones I've practiced in front of, and they don't like these disputes. But at the same time, the cleaner it is, the easier it is for them to make their decision. I tell all landlords, if you have a ledger, that ledger should be clear, concise. How much is late fees? How much is court costs or attorney's fees if they're included? How much are damages? I want that judge to be able to look at that for 20 seconds and know exactly what each line item is on that ledger, because I don't want them for it to be open for them to interpret what any of it means. Does that make sense? Oh, Tanya, I think you're still muted.
Yep, it does. Thank you very, very much.
Yeah, like I said, and I'm not saying you can't do it, but if I was going to give my advice from my own experience, it would be, I'd just take a double security deposit. All right, so COVID. First off, we have the CDC order. The CDC order is very vague and confusing, and it has really disrupted landlords' eviction processes since it was enacted in early September. What we do know is that eviction in the CDC order means removal from a property. It doesn't mean filing a lawsuit. It doesn't mean pursuing your claims. So initially, that was our concern, is that this was some sort of moratorium that prevented us from filing anything, which I practice in Illinois as well. The moratorium from the governor in Illinois, you can't file. Filing would be a violation. So we know that under the CDC order, eviction just means putting someone out. So if you file an eviction and a tenant serves you with an affidavit that meets these certain filing requirements that are identified in the CDC order, it puts off the eviction until December 31st, 2020. So what we've been doing is just continuing the matter to the first available date in January. We have the lawyers who practice in my area, we've all come up with some ways of dealing with this, and we have been able to effectively prove that certain tenants have put forth to the court that they've met these requirements but haven't actually met them. And then the judge has told us that we are allowed to proceed. So there are some leeway here, but honestly, if you get one of those notices, you should stop whatever it is that you're doing, right? When it comes to pursuing that eviction. It only applies to evictions for non-payment of rent. So like we talked about unlawful detainers earlier, providing notice because you have a month-to-month tenant, even if that month-to-month tenant's not paying rent and that's why you want to terminate them, it doesn't matter. You can still proceed on any of those claims. It only covers individual tenants that are being evicted for non-payment of rent. So any eviction that was filed prior to September 4th, I don't know if there's anyone on this call that has stuff that's pending that's been delayed as a result of, COVID cases increasing in certain counties, causing the courts to shut down or extend timelines. If you filed before September 4th, which was when this particular order was issued, this does apply. So now if you had a judgment from prior to September 4th, it does not apply. This order, and again, this is an executive order. There's a very big question here as to whether or not the CDC has the authority to do this. But this order, as of right now, expires on December 31st, 2020. We don't have any evidence to believe that it's going to be extended, although I think only time will tell as to whether or not. We're just going to have to see what happens with the COVID cases. So locally, though, we have an eviction moratorium in the city. So any properties that are inside the St. Louis city limits, right now that moratorium expires on November 6th. We believe it will be extended to the end of the year, but it only applies to rent and possession. So if you have a tenant that is doing anything illegal in the property for a 441 filing, it does not apply. Commercial evictions, it does not apply, and unlawful detainers, it does not apply. So if you're terminating for any reason other than non-payment of rent, you can still proceed through the entire process in the city. St. Louis County, on the other hand, there unfortunately a sheriff's deputy passed away in late March, and the presiding judge issued an order to the sheriff's department in St. Louis County shutting them down. They have not reopened as of yet, and they're not communicating with us at all as to when that will happen. So the sheriff's department in St. Louis County, they're not serving summons, they're not serving garnishments, they're not doing anything. So in St. Louis County, you can proceed all the way through judgment, but you can't get your tenant out. It is my understanding, though, as the way that they're letting us file, if you proceed forward now, obtain a judgment, you get in line behind people who wait to file. So it isn't necessarily in your best benefit to not do anything, but at the same time, be aware that if your property is located in St. Louis County, there is no way to get your tenant out. I do suggest now some things I haven't suggested and I normally don't. I mean, negotiating with your tenant, getting payment plans, cash for keys usually is a really hard thing for me to recommend to anyone, especially when I know you have a past due rent balance. But if you really need your unit vacant for some reason, like you're selling the property, it's contingent upon it being vacant. These are some of the methods that are working right now, but it's a tough spot for everybody not having any of these departments really working and moving forward the way that we're all used to on the normal timelines. Okay, so that is the end of my PowerPoint presentation. So, and it looks like 7:51. Okay, I stayed within John's time frame. I feel really good about that. So questions. I know I've really run the gamut over things and you guys probably have a lot of specific questions. So I'd love to just hear out what anybody has to ask.
Diana had another one on there back to the security deposit. She typed in, but she can't unmute herself. To go back to the security deposit, I thought that the need to maintain a segregated security deposit account only applies to realtors. True or not true?
That is not true. Diana is absolutely right in that this started about 5 years ago because the Missouri Real Estate Commission issued a special order to real estate agents who were acting as property managers as well as listing and buying agents. But this rule has been codified by the Missouri legislature to spread across all landlords. You have to own 5 or more doors, though. So if you live in a 4 flat and you live in one and rent the other 3 out, you don't technically, this doesn't apply to you. But if you have 5 or more doors and not 5 or more properties, 5 or more doors, then it does apply.
Sorry, I was hoping to ask a question since I'm really new to the real estate game. I'm not really an expert on the tax structure advantages. Could you tell me a bit about why partnerships are the most advantageous? Is it just because they avoid double taxation?
it's a partnership tax. So let's say you own your entity individually, it's called pass through, but if you own your entity with another person, it's partnership taxation. The reason why it is less expensive is because it's a pass through. As Mr. Steyer said earlier, you get issued a K-1 that flows directly through to your personal tax return. Your tax as it's passive income, so it's taxed as a lower rate. And instead of having to file a separate tax return, so like an S Corp requires a separate corporate return, that corporate return then issues paperwork to you individually that has to be filed with your individual return. So you save a little money with your accountant and you are passing that income directly through to yourself. So you're getting taxed at a lower rate than your active income.
Thank you.
Okay, I'll ask a question again. So if I happen to be one of these unfortunate landlords that have a overdue tenant, once I eventually get him out, what's the best way to collect the money in arrears? Is it to go through an attorney or a collection agency? How should I go about that?
So I think that's really, it's up to you, right? Collection attorneys and collection agencies have different payment structures as to how they make their money. There's a great collection lawyer that I refer landlords to who's in Chesterfield, and he's the only attorney there, but he has a staff of 30. You just need somebody that has the ability to do the skip tracing, make the phone calls, and try to actually like really collect. I mean, I wish my office had the resources to do that part for landlords, but our staff is focused more on other aspects of real estate. But I would be happy. I'll chat in my email address. Send me an email and I'm happy to send you a name for an attorney that I work with really regularly. He does a great job collecting landlord judgments. And I guess actually, as you bring this up, one of the other things that you can do right now with a tenant that isn't paying, if they have COVID non-payment issues, because I will say there is a lot of tenants I've dealt with recently who they're just not paying because they don't think they have to, right? They haven't lost their jobs, or they haven't really had that, haven't been sick or had a family member that was sick. St. Louis City has stimulus money that the tenant can apply for online through the city's website, STL Cares, the STL Cares Act. If you Google that, it'll bring you to that page of the website. Now, if you accept stimulus money, whether it's through Catholic Charities or any of the organizations that are helping tenants pay, you have to keep your tenant in the property until the end of the year. So I have some clients that have, absolutely collected a ton of stimulus money, got their tenants current, but I have some clients who've just chosen not to take it because they don't want to be in the position where they have to keep their tenant until the end of the year. And if you email me, I'm also happy to send you those resources and the links.
Fantastic, thank you.
Can we go back to the series LLC real quick? You were talking about how you put each of your rental properties in a separate series. But what if you do like fix and flips and wholesales? Can you designate one of those series for that, or does that have to be a separate LLC completely?
You absolutely can. Yes. It becomes just a little bit clumsier. You have to keep track of which series entity you're using for those purposes. So I would say if you are going to do, how many properties do you hold that you're wholesaling or flipping at the same time? Usually.
Well, we have 5 holds right now, and we had acquired some that we did sell. So we did a flip, but then the other properties that I knew that we were going to either wholesale or flip, I've only put into like one LLC, and that's been like 4.
So what I will say is, if you're, especially because you have a decent amount of volume, I mean, if you only have one that you're wholesaling or one that you're flipping at a time, then you can just use one LLC for that you keep separate. But I will say, so if you are holding that much, having a series specifically for the wholesaling and the flipping and a separate for anything that you hold. So if you're going to rent anything out that you're going to keep as a portfolio, keep that in a completely separate entity, because your liability as a landlord is different than your liability when you're wholesaling or flipping. Flipping liability is like contractor issues. You know, you don't want that to merge in any way, shape, or form or be a part of the same sort of entity that you're holding rental property in.
Okay.
So, but yes, absolutely. I think that if you haven't, if you're doing as much volume as you have, then a series entity is great because you always know it's in Julie 1 entity, and maybe this particular property is in series 1, or you can name your series whatever you want. They don't have to be numbers or letters. They could be, it's anything arbitrary, but it makes it easier to separate that out for your own personal accounting too, right? Because any of the tax issues that you might have when you're flipping, you know, capital gains and things like that, keeping that in one entity is just better, and it's easier on your account, and it'll make your accounting bill cheaper.
Okay. All right. Great. Thanks.
Looks like Paul typed in a question. I don't know if you could see that, Julie. It says, if tenant stays past a mutually agreed upon termination agreement, are they required to pay double rent as a holdover?
So yeah, great question, Paul. So it's part of the unlawful detainer statute. It's also probably in most of your lease agreements, but yes. So the statute says that the landlord's damages for the holdover period. So I'm served with notice to vacate by the end of October, November 1, I owe the landlord double damages. So in court, if we were to try an unlawful detainer matter, we would ask for double damages and we would get them. The statute absolutely allows for it. As far as collecting it pre-filing, that's going to come down to that individual tenant and what you end up working out to try to get them out. But if your lease agreement says that if you hold over past this date without a renewal, you owe double rent, then your ledger should reflect double rent.
Sorry for a potentially dumb question. I was remembering your slide on the security deposit statutes, and it said, I think on the first line, that it's either money or property. I'm a bit confused how the property as a security deposit would even work. Like, how does that?
Well, some people will give like a diamond ring or some gold or something as security. It doesn't happen very much anymore. But the statute is made up to say that, because people will, and that happens more often in a really high dollar rentals, which it doesn't seem like it's that common, but you'd be surprised. Like in Ladue, there are people that rent houses where rent is $10,000 a month. And so for that, a landlord might take as security a piece of property or even a lien on a vehicle, things like that. It happens every once in a while. So, but you could absolutely choose, if, you know, say, I know you don't have $500 to give me, but I'll take this, you know, $500 ring.
And you would have to get that appraised, right? Because you want to confirm that it's as valuable as they say it is, right? Somehow, or like go to a mutually agreed upon appraiser or one of your choice, right?
Yeah, absolutely. I mean, that's a slippery slope. Just take the money.
Yeah, I would guess it'd be easier to just take money. Yeah.
But it
I was
definitely,
wondering.
like I said, I've seen it happen a few times where it's like, I don't even know how to deal with this as a security deposit, right? How do you what if you owe them half back?
Yeah, that seems like kind of like a slippery slope, as you said, like, you know, about like different owing amounts. So I was just confused about the property, because I would only imagine you would just give out cash in hand or something. So
Yeah, no, but I said in really, really high dollar rentals, I've seen it's also really common in commercial leasing. Tenants will give security interest in their equipment.
sure. Thank you. Appreciate it.
Are you ready to talk trusts?
Oh, yes.
Okay. My understanding is that the trust has to own the property when you fund it. So.
Well, funding a trust is transferring property into it. So like, think of a
Yes.
trust like a non-registered company, like a non-registered LLC.
Okay, that brings up two questions. One, if you're moving it into a trust, I understand there's something in the law that says the city, like, or a municipality like a bank, cannot consider that a due on sale or come and do more inspections because it hasn't been inspected for a year. Do you know anything about that?
Okay, well, I think
Because,
that's
that would be a
two
great thing if they
questions.
could not do that.
So
But,
the due on sale clause, it depends on the language of the deed of trust, right? And I've seen different banks, like there's some banks that their standard language is that if you transfer the property into a revocable living trust, it's fine, right?
yes, right.
So I still think the due on sale clause is really a misnomer and probably not going to be a problem for anyone. But generally, a revocable living trust is still just you, right? It's not
Right.
registered. There is no limitation on liability. It doesn't do anything like what an LLC does. It's an estate planning vehicle, right?
Yes, that's what
So-
I understand.
Yeah, so transferring it into it shouldn't trigger your due on sale because you haven't
No, not
changed
due
it
on
at all.
sale. The inspections where the county or the city comes around and says, we want an inspector to come in and see that it's habitable.
Okay, so the thing about the inspections, like I said, that's a different, first, in the city for sure, when the inspections trigger is when the utilities change.
Right,
So if you have a property that you own individually and I move into it, and 3 years down the line, you set up an LLC and transfer it into the LLC, the city doesn't have a right to come and re-inspect your property merely by the transfer. Those cultural resources occupancy permits, I mean, they really are just occupancy limit permits. Those are triggered by a change in tenancy. Same tenant is there, nothing has changed, right? So
okay,
usually when you get those triggers are like, I'm living in your property for 5 years and then my boyfriend moves in and my boyfriend transfers the utility bill into his name. Then the city gets notice that the utility bill has been changed. And that's when they call you and say, hey, I want to re-inspect. And you say, no, I have the same tenant.
yes, that's defendable. But to get it into a trust on the tax records, doesn't it now have to reflect the trust name?
Well, in order to transfer property into a trust, yeah, you have to deed it into it. So the
Okay.
Julie Ostrom Revocable Living Trust dated October 20th, 2020. In order to fund a trust, you have to transfer property into it. It has to own something.
Okay, that's probably the question. How do you do that? Because I signed up with a group online and they say we do everything in Nevada. It's easier. I've heard it from other people since then that Nevada's a problem and doesn't work here in Missouri. So what's the advice?
So you're talking about a real estate investment trust or your own personal trust?
My own personal property.
Okay, so here's a good example. In our office, when we execute estate plans, right, we will execute a document called a general assignment to trust. A general assignment basically says all of your personal property that isn't individually titled, like your car has a title, your real estate has a deed, right? So we do that saying all my personal property, my clothes, my jewelry, all the stuff in my house is transferred into my trust, right? But to transfer real property into your trust, you need to prepare, execute, and record a deed transferring it from your name or whatever name the property is in into the name of your trust.
Yes, and it's an LLC. So I could sell the LLC, the trust. I could sell it that way and still leave it in our name. Because my concern is that it's out there in my name if they look up the LLC, and I think you want that to go away, not because it gives you an added layer of try to find me.
So wait, so your property is owned by an LLC and the LLC is owned by your trust?
It's going to be.
Yeah, no, then you shouldn't have that problem. So there's two places that information is public. One is on the Secretary of State's page, right? When you
Yes.
register an entity. So a good reason to hire a lawyer to set up your entity is your lawyer is the organizer, right? And then
Yes.
you have a corporate registered agent. So nothing on the Secretary of State's page says anything about who actually owns the entity, right?
Right.
The other place is the assessor's office pages that are available for St. Louis County and St. Louis City, where you can do real estate lookup, the taxing address. So
Yes.
my suggestion is have your tax bills go to either a business office or PO box. That way, if you don't want a tenant, for example, to find you, if they look up your property on the assessor's office and see that it's owned by Mr. Steyer's LLC, right? But then they see your home address, all they gotta do is pop your home address into Google and they find you, right?
Sure.
So
Yes.
just make your taxing address a PO box and have your
Well-
tax bills go there.
Okay, they're already there, but if you look it up the way it's listed right now, it would say we formed the LLC, and I think we need to get our name off of that part of it, correct?
Yes. That's a hard thing because all past filings on the Secretary of State are visible.
Well, it's still
So-
passed.
You're right. So like if you went online to the Secretary of State and paid and set up your own LLC and put yourself as the registered agent, yourself as the organizer, even if I came in and amended that LLC and made myself the registered agent, the past filings are still visible.
Sure.
So you might be in a better position to just start something fresh.
That confuses me even worse than I was to start with, because I know the attorney with the group that's doing this did not seem to know how to handle that. They said, no, we leave it in the way it is right now with the city, with our names or our LLC's name and our mailing address. And we use PO boxes like we've been advised by you attorneys. So, and I say, well, something doesn't ring right there.
I mean, is this attorney, this is someone licensed in Nevada?
Well, I know they're licensed in this state. At the risk of being wrong, let me give you a name. Well, you're fortunate. I don't get to see it right now.
Well, you know what? Do you want to call me tomorrow?
I might do that if you're.
Yeah,
off
we can have a specific chat because then we'll look up one of your properties and I'll look and see exactly what it is that you're seeing. And we can talk about if there's a way to fix that. But
Yeah,
I do
well, nothing's
understand your goal is anonymity here and there is a way to do it. But this sounds like the attorney's telling you to title the property in the trust, which that's got your name on it.
She didn't know she really didn't know what to do. That's the real bottom line. And I said, well,
Okay.
I don't want it in my name because if another attorney, say John Lee attorney, comes over here to sue me and he sees my name, then he can attack me as the owner of the LLC. And I said, it should be in the name of our trust. And she said, I'm going to have to think on that, and then disappeared. But I mean, the organization is still there. So
Yeah, I mean,
there's a
your
complication
LLC
there
should be
that
owned
I
by
don't
your
understand.
trust, yes. But your
Yes.
property should be owned by your LLC. So, yeah, no, we can, like I said, we'll look at a couple of your properties online tomorrow and I can give you some better information, more specific to you.
Okay, what's Julie's phone number?
314-772-2889.
That's your main switchboard downstairs?
Yeah, just tell Todd
Oh.
you're calling for me.
Okay, I got you. I probably have you in my phone. Okay, thank you for
Yes.
that.
Okay, so we had a question come up that said the county is now asking for street addresses and not PO boxes. Not to my knowledge. I haven't had any issues changing over clients in the real estate records for the assessor's office to PO boxes. And we still put PO boxes on deeds when we record them in St. Louis County. So Steve, did somebody tell you that at the collector of revenue or at the recorder's office?
My son went to record and said, no, it has to be in a street address.
Certain
Well,
municipalities are requiring a home address for the property owner. Woodson Terrace, Berkeley, to name a couple.
so those municipalities, though, I will say, are keeping those records are private, right? I can't access Berkeley specific records. All I
Correct.
can
That's
access
just for their records, yeah, for
right.
the
And so,
landlord
and that might
agreement.
be.
Mhm.
Oh, I'm sorry, David. I'm sorry.
No, that's okay. I was saying just for their records, for their landlord rental agreement.
And their permits, yes,
Yep,
that
for
they are,
permitting.
yes,
Mm.
yeah. And I will say, it is my understanding that the municipalities do, but that is not publicly available information.
Hopefully not, yeah.
Thank you.
So I'm gonna do oh yeah, that's the other, this is a good point. Dan posted. So there's also now a bunch of these UPS locations that are around the city, around St. Louis County. They are giving addresses that are physical addresses with box numbers, and they're not PO boxes anymore. So that's an option. I know that there's one in the Schnucks Plaza that's right by St. Mary's Hospital that you get it. It looks like a real address, but it is still just a box. So, Steve, maybe what your son heard is that he was trying to get a permit for an individual tenant in a particular municipality that was asking for a good address for.
I thought that was St. John.
Oh, yep. You know what?
If
It's
I
my
remember it
understanding
right,
that
that
St.
was
John,
St.
yes, that makes sense.
Okay.
See, I love you guys. We always have these like really big, expansive conversations.
Sorry, another question. So am I understanding this correctly? So for each property, you want an LLC to own that property, right? And then you want an overarching trust to cover all of the LLCs. That way you can hide your name. Is that correct?
Well, they're not, well, the LLC in and of itself could keep your personal information from being publicly or easily available. The trust portion is it's part and parcel to being a property owner that holds rental property, is that you also need an estate plan in place. And that prevents, if something were to happen to you, I mean, one of my partners always says you can get hit by a bus at any point, right? If something were to happen to you, well, then what happens to your rental properties if you don't have someone or a plan for someone to step in?
Oh, it's a succession plan, basically? Okay.
Well, so in some respects, a succession plan, yeah, but also, estate plan.
Okay. And how would you apply for this trust? Like similar process to anything else, like an LLC, or like do you go to somebody and like, I want to set up a trust if I have enough properties in tow, for example?
Well, honestly, most people should have a trust because a trust avoids probate. But no, you would go to an attorney who can prepare a trust agreement for you and look at all of your assets and your future plans and everything like that. So that, because a trust, I said, it's an estate planning vehicle. It operates similar to a corporation or an LLC, but it's not. It is not a limitation on liability. It doesn't protect you in that way. It protects you from probate, and it allows you to make specific directions about what you want to happen to all of your stuff after you die.
And if you didn't have that trust, I'm assuming the government would be like swooping in and they get to disperse the assets as they see fit or something, or how does that work?
No, you just have to go to court. It takes about a year to go through probate. So it would be an estate that would go through probate court.
Yeah, Julie, it's a fair statement, isn't it, to say all a trust does is gets it out of the court and things move over to people in a hurry.
Yes.
Okay.
Yes, and I will say the probate estates are difficult because, this is a person who comes to me that needs me to ferry them through the court system, but they've just lost a loved one that was so important to them. They were the person that they picked to make all these decisions. So when you can have a trust administration as opposed to a probate, it's so much faster. Plus, you can, like, if you have minor children, you can set up a trust that pours into another trust that makes it so you don't have a 6-year-old that's just inherited $100,000, right? And the money can be put away, or you can determine where it goes. It's for education, it's for welfare. So the estate plan part of it is part and parcel to being a property owner, especially because if you have rental property, having tenants, it's just good to have a plan there. But it's not necessary.
Sure. So the LLC is for anonymity, but the trust allows you to move your properties around as you see fit without going through the courts.
Well,
right?
only after you die. Yeah,
Only after you die.
Yeah, LLC lets you move your properties as you see fit. But the trust is part of like a will, trust, powers of attorney. It's part of an estate plan.
Well, for anonymity though, you'd want a registered agent for the LLC. Otherwise, everybody knows who you are.
And the organizer. Yeah.
Yes,
Good job.
absolutely.
Jim, you're right about that. Like both of those things that's the first thing you see when you open a document on the Secretary of State. So like
Sorry,
our office, we have an entity called Magnolia Registered Agent. Our office is at 3500 Magnolia. So we operate as registered agent for a lot of LLCs. So when you actually look at the articles on the Secretary of State's website, which that's all public, it'll show the registered agent is Magnolia Registered Agent. And all a registered agent is just a physical location for service of process. So if your entity gets sued, this is the entity that we serve, right? That's where you send the sheriff or the process server. So, you know, there's that, but then there's also the organizer. It's new. They've revamped the Secretary of State's website, which has been incredibly frustrating. I am not going to lie. They're not caught up on anything right now, but they're now asking for a principal place of business address, which I found out you don't have to fill in. That's, yeah, not a requirement. So having an attorney prep your LLC though means your attorney's name's the organizer, and then a corporate registered agent's the registered agent, and there's nothing there to say who owns what.
So you need a registered agent and a good attorney to draft up the LLC documentation. Am I understanding that correctly?
Yes. I mean, I'm not going to say you can't do it yourself, but I highly suggest not using LegalZoom. I've cleaned up a lot of Delaware entities for clients that didn't need an entity in any other state, you know, so, but yes, I mean, obviously as a lawyer, I think that using a lawyer to do legal things makes the most sense. Representing yourself in criminal court is a really bad idea. So
Right.
I'm just gonna say, like, yeah, so of course I suggest that, just like, don't do your own taxes, hire an accountant. But
Right.
it's not that expensive. I mean, our office charges $450 to set up a single member LLC. So it's absolutely cost effective, and it's in your benefit if you want to make sure that there isn't any personal information out there.
And for a trust, is there anything like a registered agent for that too, or like no, you just go to an attorney and he or she helps you draft up documents? Okay.
Yep, trusts are not registered publicly.
Now that's a plus and a minus, Jonathan. So there's almost a whole class that Julie can probably teach you on a one day to tell you what a trust will and won't do and how they structure and who gets served and who has to do what. It's not
Okay.
really simple. But Julie, the place is called Premier Estate and Income Planning LLC that I'm dealing with. I don't know if you know them or not.
No.
And it's all online.
Well, they spend a lot of money on their SEO, that's for sure.
Yep.
So is that through
They do.
Tucker Allen?
This was through a Scott Garcia. He's supposedly the president.
Ah,
Apparently they're owned by another company that's owned by an attorney.
found it.
Whoops. John Lee said if I could stump you, he'd buy me dinner, by the way.
Oh, well, good luck. You still have it.
It ain't gonna happen.
I mean, I'm not trying to take the dinner out of your mouth. But yeah, no, this is interesting. Okay, well, I'll have to peruse his website. It says he's from South St. Louis.
Yes, and we'll talk tomorrow. I heard them advertising on the radio that they were around chasing the old people to get them to do trusts like that. And, you know, my point about doing a trust is they say you can't beat taxes or death. Well, if you have a trust, you beat taxes. Good point, huh?
Yeah, well, I mean, our estate tax is so high right now. You know, you're going to be inheriting a lot of money to really end up paying a lot in estate taxes, but eventually. Oh, we have a question. We've got some good advice actually on here too, but then do we offer flat fee estate planning services? Yes, actually, in fact, our office, you call in, make an appointment, we meet with you, talk about all of your assets, what your goals are, and then we give you a flat fee price after that first consultation. And then estate plan review, I guess it depends. Estate plans can vary. It depends on you individually and what you need. So there's estate plans that are $400. There's estate plans that are $2,500. It just really depends on each individual person, which is why we do the free consultation and then sit down and talk. And what's your goals moving forward? You know, it makes a difference based on your age and life experience and career. Right, I think I was like, I was trying to go through the chat. I should have had this open the whole time. It would have made everybody's life easier.
You answered most of the questions real well, but yeah, there might be a couple things in there. One of the things I was wondering, what I think Lois said here was, you can use the street address of the physical post office and then just add the number as a suite. I guess that's your box number. Is that possible?
I don't know, but I'm guessing that we've got somebody here who maybe has done that before.
I have.
I've never.
What's your experience there?
Well, when I did it, they told me that I could use the physical address. My lawyer did, so that's what I did. I used the physical address, and then they just attached the PO box to the end of the address, and that's what shows under your business.
That's interesting. Okay, thank you.
You're welcome.
I have seen one on my structural engineer. He gave me everything, and then I checked it out. It was post office box, had a post office address and a box number, you know. It didn't say PO box, like this one, you know.
Well, that makes sense.
No.
I mean, I mean, that's what it is. It's the address of that location plus the box number. So
I like that.
it's good to know. Thanks for sharing that.
Oh, you're welcome.
Hearing you guys talking about PO box numbers as a way of providing a physical address, how do you guys get access to those? Is there you go through an attorney again, or I'm not
For
really
a
sure
PO
how-
box?
Yeah.
You just
Or
go to
just
the post office and pay for
okay,
one.
okay, all right, okay.
Yearly,
I'm
there's a
thinking about this
yearly
too hard.
fee. Yeah, like, but it's not just USPS, the UPS stores have them. Yeah, so you just go, there's a fee that you pay per year.
Yes, there's a fee you pay per year, but I did go through my lawyer to have that address attached to my business. And if you don't pay this is important because I forgot when my fee was due. So it changed my PO box, which changes my address. So you have to get your lawyer to amend that address the way you set it up and change it so it registers right with the state. If that makes sense.
Yeah, no, it does.
Just use a registered agent and the address stays the same. The
Yep,
registered
I
agent-
totally agree. Jim, totally
Noticing a
agree.
pattern here with the registered agent.
Absolutely.
It just, yeah, it works out better. And the other thing is, if the Secretary of State figures out that you've got a PO box as your registered agent, they will administratively dissolve your entity.
Yeah, I did this before I knew all about the registered agent and stuff. So going forward, that's the way I'm gonna do it, but live and learn.
Thank you, Gina. Appreciate it.
You are welcome.
Sorry, Julie, another thing you mentioned that caught my attention was you noticed you were talking about bad contracts that came from like websites like LegalZoom. What contract verbiage are they missing, or what's bad about those contracts? If you can say anything about them, I guess.
Well, I mean, generalized advice is never good. It's like, take a grain of salt with it. Even this seminar, you know what I mean? It isn't specific Jonathan advice, right? It isn't specific to what your particular situation is. And I don't know, you know, maybe you want to amass a massive real estate rental portfolio, or maybe you're getting ready to start flipping houses. So this is general information that you should take, but it can't be specifically you're always going to need to take a step back and go talk to somebody individually. You know what I mean? So when you get on LegalZoom, LegalZoom's going to tell you, oh my God, Delaware law is the best law in the whole world. You should have a Delaware entity. Well, if you are a single employed architect who lives in the state of Missouri and only works in the state of Missouri, having an entity that requires you to litigate in Delaware, having an entity that requires you to file an extra tax return in Delaware really doesn't make any sense, right? So one of the things that I shy away from with the generalized legal advice that you can get on the internet is that it isn't specific to you, which means it'll always have holes. But as far as like, can I pick apart individual? Not really. You know what I mean? I have some anecdotes of stories from different clients of mine, but it just really depends on what you're doing. I mean, and like I said, this particular group runs the gamut on real estate experience. This is not just people who, I'm just not talking to a group of landlords. You know what I mean? There are people who have taken hard money loans, people who give hard money loans. I mean, this is so this, like I said, again, even what I'm saying, you should take as generalized advice and figure out, these are certain things I want specific advice on.
So it just has to be personalized to your particular situation. That's what makes the contract valuable, I guess. That was
Yeah, personalized to your goals.
Like, that's why you go see Julia for the first time to say, this is what I want to do. What do you think? And how do I do it? And she's not going to charge you. And after that, she'll charge you, but it's cheap money when it keeps you out of court.
Or she'll laugh
I
at
didn't
me.
know you became my boss.
Good advice.
I am not your boss. Let's clarify that.
Well, now you're telling everybody I'm not going to charge them.
I thought you said that earlier, that
I'm
you.
not really ready to be diving into this just yet. I just wanted to hear a bit about the opinions, I guess, from the experts.
Yeah, no,
here.
that's really good. It's what you should do. That's how you're going to get better. And there's all these people here who have, I mean, like Gina just gave us some great information. Like, just, you got to be around people who've been doing it and they can share their experiences. But yeah, like I said, I think each individual person has, it depends on what your goals are.
Makes sense. Thank you.
Yeah, so Julie, potentially rookie mistake. I did set up my LLC through LegalZoom. They didn't make me incorporate in Delaware though, so that's good. But would it be beneficial to have someone like your office look it through what they set up just to make sure that there's nothing missing from it, or it's not too generalized specifically? Or
do you
like,
own it yourself? Is it just you?
Yeah, it's just me. Yeah.
You're probably, if you decide to bring on a partner, then yes.
Okay.
But right now, when you're a single member LLC, it's just you make all the decision. There's no corporate formality that's required. So yeah, I bet your operating agreement basically doesn't say anything.
Probably not.
Standard. Yeah. But right now it doesn't matter. So I would take the money that you have and use it for your next real estate investment. But if you decide to bring on a partner in that entity, then yeah, you need to see a lawyer and make sure you're protected and make sure that you have fail safes and stuff inside that agreement, because the ones I've seen are just so general that, like I said, they literally are 18 pages of nothing.
Right. Yeah. Okay. Cool. Thanks.
Julie, you said earlier that the series LLC is if you want to have more than a few rental properties under one LLC. Is that correct?
Yes.
Okay. So you should set that up front as opposed to doing individual LLCs.
Yeah, I mean, if you decided you wanted to change over how you're holding your portfolio, you can set up a series at any point, and then you just deed your properties from the LLCs they're currently in into a series.
Okay, great. Thank you so much.
What I'm hearing from what you've been talking about so far, Julie, you've been giving a pretty good selling pitch for series LLCs. Are there really any disadvantages that you could note of compared to a regular LLC? I guess like you have like 10 LLCs, each with their own unique property attached to what. Is there a disadvantage compared to that particular setup? Or, I mean, not sure. I mean, maybe it's extra anonymity.
Not in this context. Like I said, I can tell there's a lot of other types of businesses I'd never suggest using a series LLC for. In fact, real estate holdings, and I have a client that owns a bunch of McDonald's. He's got each McDonald's location is in a different series. But other than that, I can't think of a reason why it was even created. It's like a total legal fiction, right? And it actually, the first state to enact a series LLC happened when I was a first year in law school. And the concept of it is clearly it was designed for people that own rental property. So no, it's cheaper. it's easier. It's only one tax return. You're going to keep track individually of each property anyways. So whether it's owned by each separate LLCs or if it's owned by a series, you're going to be doing the same landlord or flipping accounting that you would do anyways.
So if you have 10 properties under that series, you have 10 Ks.
Well, yeah, you'd have 10 series under that entity.
I mean, if you have 10 properties, for example, you have to have 10 Ks or each individual property, right? For
Did you say 10 keys?
10 K, Schedule K.
Oh, no. Nope,
No.
it's one. You're talking about a K1, right?
Right.
Just one for that whole entity.
Oh, okay. Thank you.
Yeah, I mean, that is actually, you would, if you had 10 different LLCs,
Right.
then yes, you would have 10 K1s. But when you have a series, it doesn't matter how many series, you still just have one LLC that issues that one K1.
Oh, okay. I see.
Series can become a little complicated in that each series could have separate ownership, but then you might as well just have separate LLCs.
All right. Thank you. Got it.
What is a K1? Sorry, I'm not really used to the terminology yet. I'm trying to learn what all the different things you guys are throwing around are. So what's a K1 exactly?
And K1 is it's what a entity issues to the owners regarding their particular percentage of profits or loss. So it's the document. It's just like a W-2, you know, that has all the little language on it, little codes and everything that you enter in when you're doing your taxes. A K1 is just like that, except for it, instead of it being your W-2 income you receive from your employer, it's your schedule of profit and losses from an entity that you have ownership in.
Or just dispersion of profit, basically a document outlining that, basically.
I'm sorry, you're a little muted.
Oh, sorry. I just wanted to say, so it's just a K1 is just talking about dispersion of profits from an LLC. Is that
Profits and losses? Yeah, it's what the LLC issues to each individual member for them to be able to account for it on their own taxes.
Okay, that makes sense. Thank you.
And I am not an accountant, right? I'm never say
Of course,
that.
of course.
Yeah. So, but I get my own K1. So.
Julie, it's been most informative for me. And so thank you very much for joining us. I don't know if what else we're going to do, but what time tomorrow morning would be a good time for me to call you?
I have my normal docket, so after the lunch hour, if that works for you.
After
'Cause I have like 7 trials.
Trials,
Yeah, we're doing them over WebEx.
not evictions.
Yeah, they're eviction trials. That's why I can
Oh.
do 7 because they take me like 10 minutes each.
I got you. Thank you anyway from mine. I just really appreciated what you did
But
today.
yeah, no, like I said, if you call me after the lunch hour, I don't have anything scheduled in the afternoon, so I'll be around. But I just know from 9 a.m. until noon. Well, I do see another question. So this is a question about a particular phrase regarding annual meetings. What would that phrase be when there's an oversight for failing to hold an annual meeting? I'm not sure I understand this question. Diana's still muted though, right? This is our friend that hasn't been able to unmute.
Yeah, she can't unmute, so yeah, she's typing that in out.
I mean, anybody can waive a meeting. The members of a corporation or organization can waive the right to a meeting. I usually draft my operating agreements, though, not requiring annual meetings. I mean, if you have like a board of directors and shareholders, I mean, then you need to have meetings. But if you've got 2 owners, 2 investors in a real estate company, you guys are meeting every week anyways. You're talking regularly as you're going to look at properties or meet contractors. So I usually write my agreements to indicate that meetings aren't required, but could be called. But yeah, you absolutely can waive an annual meeting, and you would just need all the members of an LLC or organization to sign a resolution waiving their obligation for an annual meeting. Yay, okay. I can,
So what if you are a single member of LLC?
yeah, you don't need any meetings.
Do like I do and have your meeting on the beach each year.
There you go. It's John's way of
I
thinking.
should follow you.
Well, we know who Steve's gonna get into business with.
Okay.
Very informative, Julie. You've covered a lot of ground, and I really like what you did say, though, especially everything is specific. What you've given us is such great broad information, but specific questions, and that's one reason it's, you know, one size does not fit all, like you said. It's just, you know, yeah, you can go to Delaware or whatever it is, the, you know, online stuff, and that's all fine for maybe getting started, but that's not, I wouldn't even do that as far as setting up anything.
I don't think it makes a lot of sense to have it. If you own property in Missouri, why do you want an entity in other states? And people have told me, well, they don't charge income tax, but you don't live in Nevada. You don't live in Utah. You live in, you still have to file a Missouri tax return. So there is, there was a period about 5 years ago where there was a lot of big giant seminars, like at the Enterprise Center, you know, and there was a lot of people talking about flipping properties and buying properties. And you're better off buying where you are, because the clients that I have that have properties in California, you're not there, you can't see it. And I have clients that live in California that have properties here. I mean, I have this lady, if I could find someone to just take this property from her, but she can't give it away. And I mean, she bought it, it was in disrepair, she put money into it. Then before we got tenants in there, then there was squatters in there. Then the squatters ended up burning the house down, and now she owns a vacant lot. I mean, and she couldn't manage it because she's not here.
Mm-hmm.
So yeah, I mean, it's if you want to be a good landlord, you want to be a good property owner, got to be around, you know, either that or you have to have foot on the ground people where your property is, and you are receiving monthly reports, but you've got people actually taking care of it and going by it and making sure that everything's okay. So yeah, I don't know. I can see that there's some tax benefits to some of this stuff, but I guess I would really want to know exactly how big of a benefit it is based on how much work it takes.
Mm-hmm.
So there's a cost benefit analysis to everything.
Mm-hmm.
And again, I will reiterate, like I said, my information here is general, but I'm happy to talk to anybody that wants more information. And, you know, and again, referrals, and if people want a referral to a collection lawyer, collection agencies I work with, I'm happy to pass all that information on. So yeah, I'm really happy to be here. Thank you for inviting me. And like I said, I'm sad we weren't in person because I've always enjoyed this group.
Yeah. Thank you. Would you like to put your contact information that you would like to give to us in the chat, please? And I'll go ahead and make sure, I'll write it down too, but just so you put in the way you'd like for us to get a hold of you. And just not afternoon tomorrow, because that's Dwayne's designated time. We know.
Yeah.
You're tough, John. You're tough.
Well, I gotta buy you
Actually, I have a meeting with a sewer scoper at 2:00. So.
Oh, okay. Just don't climb on the ladder and hurt yourself again.
Roger.
Okay.
Julie, would it be possible to get a copy of this PowerPoint, or is it proprietary and you'd rather keep it to yourself?
Oh no, I would be happy if you want to send me your email, I can send it to you.
Sure.
I don't know that it's that informative, but I would be happy to send it to you.
I mean, I found it helpful. I mean, because I'm new, I'm just trying to learn from people like you and everyone here in the group. So any information you'd be willing to give, I would appreciate. So, it's in the chat if you're interested.
All right. Thank you, Jonathan.
Yeah, we have any other questions? We really appreciate your time, Julie. You've it's very valuable every time we meet with you. And like you said, it's too bad we're not live in person, but you know what? We deal with what we got right now, and we just we're really happy to have this and have you right now. And thank you so much.
Well, yeah, no, send me an email about membership. I can't believe I'm already not a member, honestly.
Oh, okay. be happy to do that.
I know you have an executive board. This was great. And I like how all the Robert's Rules of Order.
I can send you, we don't have any attorneys as on our vendor list right now either. I'll send you the information for that too, if you want to get on, display your logo and stuff right on our website if you like.
Oh, that would be great. Thank you so
Okay.
much.
I'll
Yeah,
send
and
you
tell
the
your
information.
wife, she did an amazing job. I want her to run all of my corporate meetings. She could run condo meetings. Honestly, those get really nasty.
She's a little camera shy though. That's why I had to block over the camera. But no, it was great having you back. Have to do this more often.
Yeah, like I said, I always enjoy this group because it's, you guys are diverse. You get involved in a lot of different things, and that's really important.
Sorry for my dumb questions. I'm just sort of new to this, so sorry for if my questions maybe seemed elementary compared to everyone else's. But I do appreciate all of your, time in answering my questions. So thank you.
Nope,
Jonathan, we're all still learning.
yeah, that's what we're about is education. That's our right behind. That's our main driving force. This organization is education for our investors. So you're at the right place. Okay, you got anything else, John?
No, just if anybody'd like a copy of our resource, just go ahead and put your email in the chat and I'll give that to you. It will be available for our members on the website. That's our updated resource guide for this next year. So it's full of information. If you want to buy one, you can go to Amazon, but you don't need to buy anything. We'll give it to you for free as a member. And other than that, that's about all I have.
Okay.
Okay. All right. Jonathan, you got the presentation and then, okay. Yeah, great. So you guys have my contact info if you need something. And again, it's always a pleasure. Good luck. Happy investing. Things will get better. I promise.
Thank you, Julie.
Hey,
Thank you very much.
Julie.
Thank you.
Thank you.
Bye-bye.
Thank you, Julie.
Oh, you're also welcome. It was just a pleasure.
All right.